How you doing?
I'm good. Mr. York, before we get started, let me ask you, are you expecting counsel this morning? A lawyer?
I was, but no one came for counseling.
Who were you expecting? Do you know?
No, ma'am.
You had, it's because it seems like at one point you had appointing counsel, Mr. Bobby Domingo or something like that. Do you,
I never heard of him.
okay. So at your preliminary hearing, did you have appointing counsel?
No, ma'am.
Are you ready? Well, can you, first of all, okay, we're gonna go ahead and get started. Let me just do some preliminary work and then we'll talk about your counsel if you want one. The Committee on Parole is called to order. Today is June the 4th, 2024. It's Tuesday. The time is 8:58 a.m. My name is Cheryl Renatza, serving as chairman of today's parole panel. My colleagues this morning on the panel, seated to my left is Ms. Jerry Ledoux, and to my right is Ms. Carolyn Stapleton. We are at St. Martin Parish Jail. We have before us Mr. Brent York. Mr. York, would you introduce yourself? Tell us your name and DOC number.
I'm Brent York, DOC 572813.
Yes, sir. So Mr. York, we're going to put. Let me ask the staff here to introduce themselves. Thank you. Thank you.
Jason Thompson.
All right. We are at DOC headquarters in Baton Rouge, Mr. York. Can you find this parole revocation questionnaire? We're going to put a form up on the screen and see if you there. Do you recognize that form?
Yes, ma'am. I have.
That's your signature at the bottom, dated August of 2023.
Yes, ma'am. I have a copy too.
Okay. Based on your answers to those questions, I believe it was determined you're not eligible for appointed counsel. Is that your understanding?
I was told that, and then I was told that I was going to get appointed counsel, so I really was confused.
Yeah, what is, we're gonna stand by, we're gonna check. Yeah. Mr. York, it seems as though maybe we're trying to check to see if you were appointed counsel. It's not clear in the record, so we have to make a couple of phone calls. So we want you to just stand by. We're going to go on and have another hearing, and we're going to come back to you shortly.
All right. Could I continue without counsel?
If you want to, you can.
Yes, I'd like to go ahead on and continue without counsel.
All right. Well, we're ready to proceed then. So, okay, so let me get to that. The way this will work, Mr. York, is I'm going to read the allegations against you. You understand you're here for a revocation decision, right? Okay. I'm going to read the allegations against you, after which you will enter a plea of guilty or not guilty. Then I'm going to turn it over to Mrs. Ledoux. Your case has been assigned to her. She'll take the lead on the interview questions. Before we reach a decision, you'll be allowed to make a statement if you'd like.
No, ma'am.
No, well, at the end, if you want to make a statement, I'll ask you then. Okay, so you are accused of violating the conditions of your parole, specifically condition number 3, and it states you received written permission to travel to North Dakota from July 7th to August 7th, 2023, and failed to return to Louisiana on August 7th, 2023. How do you plead to violating condition number 3?
Guilty.
Say guilty?
Well, really
Well,
not
I tell you what, you can say guilty with a statement and we'll take your statement in a minute. So is it guilty or not?
guilty with a statement.
Okay. And we're gonna take your statement in just a minute. The next one is condition number 4, and it states you fail to refrain from criminal activity by committing domestic abuse battery on August 12th, 2023. Subsequently, you were arrested by the Breaux Bridge Police Department on August 12th, 2023, and charged with domestic abuse battery. On January 6, 2024, you appeared before Judge Lewis Pittman in the 16th Judicial District Court in St. Martin Parish, and it was ordered that the matter be dismissed. Mr. York, how do you plead to violating condition number 4?
Not guilty.
Okay. Next, we have condition number 10, and it states you failed to make any payments to this account, your supervision fees, resulting in an arrearage of $567. How do you plead to violating condition number 10?
Guilty.
Okay. Then we have 2 instances of condition number 13, which are special conditions. The first is the special condition was that you attend 2 AA or NA meetings per week. You failed to provide proof that you attended any AA or NA meetings. How do you plead? Guilty or not guilty?
Not guilty.
Okay. And the second instance, condition number 13, was that you were ordered to obtain substance abuse and mental health evaluations and follow recommended treatment. You failed to provide proof of completion of a substance abuse or mental health evaluation. How do you plead to that violation?
Not guilty.
All right. Would you answer Mrs. Ledoux, please?
Good morning, Mr. York. I think that I would like to pick up right there on your not guilty, but response to those questions. Tell me about when the board ordered your special condition to do the mental health eval and AANA. You went to those? You completed those?
Yes, ma'am. I was already diagnosed in East Feliciana Parish Prison with a mental disorder. So I got out in October 2022. And I went and I got a Dr. Mika Jew at SWLA in Lafayette, Louisiana. And my PO, she wanted a picture of my medication. She took pictures of my medication and everything. So I don't know why that's even on there.
Well, on several occasions within the dialogue that your parole officer submitted, it looks like we have no proof that you went to any of those.
Yeah, I texted her my from my phone, just the proof that I had, the picture of the medications and everything, and I don't understand that one.
Okay, what about AANA? Because when you were asked, you said you didn't have transportation to go, and that's why you hadn't been going.
To the AA meetings, yes. My truck had broke down, and I wasn't able to go to the AA meetings.
Okay.
I'm the one who asked to go to the AA meetings. I went to the little scheduled appointments for every month at the courthouse, so my little monthly thing, and they had a questionnaire for the first time. And the last question was, is there anything that your PO could help you with? And I left it blank. She said, you can't leave till you answer it. So I just put, I could attend AA meetings just thinking, it was satisfied. But then she took that and made it where I had to go to AA meetings twice a week. And I told her I didn't need it, but she said it was too late. I didn't have reason to even go to twice a week like that.
Did she explain that the board actually ordered in May of last year that you attend those? So that was a board ordered special condition?
Yeah, she did that after I answered that question like that. I never had to do that. I got out in October. And I never had to go to no AA meetings. I'm the one who answered the questionnaire like that.
In May of 2023, she informed you that the board ordered you to go to those meetings. The reason I bring that up is because you were able to make the anger management classes when you knew that that might divert you from a charge, your domestic abuse charge. You were able to make those classes and completed that, and I'm glad you did. But you didn't do what we ordered you to do.
Oh, ma'am, those classes were in the jail that I'm in right now. I didn't have to go anywhere. They're already here in the jail that I'm in. It wasn't it was on the street. I needed transportation for.
You understand that a part of our report, we have photographs of your victim with the domestic abuse battery. Whether the charge was dropped or not doesn't mean that the activity did not exist, that you didn't harm her. You understand that?
Yes, ma'am. Even though I didn't do that though, she got into it with the person that picked me up from the airport. She been fighting with that girl for months before this.
And you're telling me that a girl did all of those, made all those bruises on her body in those different places?
But she fought with two people trying to say that I went over there, but I didn't even go over there to her house. I went to a neighbor's house when I came back from North Dakota. She knew that the girl brought me from the airport, and I left from the house. She thought I went to the girl's house, but I didn't go over there. She went over there to mess with the girl car, and the girl and her friend, you know, they had an altercation out there, and she took the girl's phone and just didn't come home. And I was just the next day, the police come in at the house like, you know, like I did something, and I didn't even know what happened.
Do either of my colleagues have any questions they would like to?
Yes, Mr. York, you indicated as far as your mental health evaluation and your mental health treatment that you provided the snapshot of the prescription. Was there any other treatment plan that was given to you other than the medication?
No, ma'am, I had no treatment plan upon my release.
And at the time you were arrested for the domestic abuse, were you taking the medicine like it was prescribed to you?
Yes, ma'am.
Do you still take it now?
Yes, ma'am.
Okay, good. That's all I have. Any questions? All right, Mr. York, is there anything you'd like to say to us before we vote?
They don't have an inmate lawyer here. I was just kind of going on the law library. It had LA section 155747. It said incarceration shall not be used unless I was convicted of domestic, and my charges was dropped. You know,
I think that's correct.
I've been here over 9 months.
Okay, let's move it back to the parole conditions. You're a fourth felony offender, correct?
Yes, ma'am.
Okay, so this isn't your first time on supervision, is that correct?
Correct.
Okay, if you review the paperwork that you were given when you left prison, it's very clear that you will not engage in any criminal behavior. It doesn't mean the charges, okay? So when we have evidence, and I understand you're disputing that evidence, but we have evidence that your victim had bruising all over her body, and she testified that, you know, this happened, and whether she recanted it or not, we have that evidence that occurred. So we have the prerogative to make a decision based on the evidence that we've been presented. Okay?
Even though I didn't do it, and my charges got dropped, I'm still being, it's like, I don't. It's
You're,
still saying like I did it, even though my charges were dropping, I didn't do it. So,
the fact that the charges are dropped does not indicate that you did or did not do it.
right,
Okay. Would you like to make a statement, on your own behalf?
no, ma'am,
Do you still have a relationship with Ms. Boyd?
no, ma'am.
Okay, good. All right, I think we're prepared to vote. Mrs. Ledoux will be voting first.
Mr. York, I am concerned that domestic abuse battery is a very serious crime. And based on the evidence that I have before me today, that's not been disputed, I vote to revoke your parole based on your behavior while on parole.
Mrs. Davidson.
I agree with Ms. Ledoux.
Mr. York, I find you guilty of violating condition number 3, condition number 4, and condition number 13 in both instances. And so my vote also is to revoke your parole. Today, sir, your parole is being revoked. We will send you information that will tell you have the opportunity to reapply for parole. And we'll send you information on how and when you can do that.
All right, thank you,
Good luck to you, sir.
thank you.
That concludes our business in St. Martin.